So, ladies and gentlemen, dear students, dear audience, as mentioned by our moderator, my name is Marcin Wielec. I came from Poland and I represent the Faculty of Law and Administration of the Cardinal Stefan Wyszyński University in Warsaw. In particular, it is the Department of Criminal Procedure. But in this edition of the Central European Process Network, I have the honor of leading a group of distinguished specialized professors from Hungary, Czech Republic, Slovakia, Slovenia, Romania, Croatia, Serbia, and of course Poland. In this way, at the beginning of my speech, allow me to express my gratitude to the organizers of this Central European Process Network, without whom we would not be here today. Thank you, entire management of Central European Academy and co-worker, in particularities Professor Tima Barzo, Minister Ani Korajś, Dr. Judith Varga, and of course Professor János Ade Silagi, for the trust which granted my humble person to this honorable role as a leader of our research group in such a significant scientific project. But, my friends, as we know, we are only halfway in our project, and I already want to extend my heartfelt thanks to all of the members of our research group, to the esteemed professors, legal scholars, and practitioners. Thank you very much for your valuable time, brilliant ideas, and immense support. So, ladies and gentlemen, this is already the fourth edition of the Central European Professors Network. In this edition, the focus of our group's research is the European Union, and our theme is, as we know, equality and in an ever-integrating Europe. We are dealing with the question of an appropriate balance between the democratic functioning of the European Union, the equal status of member states, and effective decision-making within the European Union's administrative bodies. On the background of this issue, we come to my field of interest, broadly understood, criminal law. So, this area of criminal law, in the broad sense, at the first theme is a link issue for the many interesting aspects of European integration, the principles of organization, cooperation, and functioning of European Union. Fundamentally, criminal law still seems to avoid this deep legal integration within the European Union. Actually, in this context arises a very important question. Should criminal law, broadly speaking, be subject to European integration harmonization process? To address this question, allow me to very briefly, outline the substantive context in where we will seeking our answers. It is important to first determine what the European Union is and what will be European Union in the close future. The first and probably the basic thesis of my speech is as follows. Criminal law has a huge connection with one of the most important features of any state in the world, which is sovereignty. In my view, criminal law, understood as one of the crucial core elements of state sovereignty, is still largely untouched by European Union integrative action. Since it's precisely on the shape and competence of the European Union that it will depend whether criminal law will be the subject of integration or the contrary, is not at all suitable for this. Two main issues emerge regarding the shape, nature, organization, integration, and competencies of the European Union. So, the first perspective, the European Union is a community of relatively equal but always sovereign states united by a common economic goal, which essentially boils down to strong economic, science, and commercial cooperation. Second perspective, the European Union moving towards a full federalist concept, understood as a single centrally managed entity where member states are just part of the big and complicated organism with significant competencies delegated to a central decision-making body. There is no doubt that the European Union is a massive entity with an enormous number of people where countless transactions take place and certainly a multitude of different problems arise. The creation of such a large community as the European Union, requires the transfer of some competencies from the member states of these decision-making centers. This transfer of competencies is natural, yes, but it must be organized in such a way that ensures effective cooperation among the European Union member states. Historically, the idea of transferring competencies to the European Union has been acknowledged since the very beginnings of the European Union. In the term of competencies, the model of the European Union is simple. It consists in the fact that the European Union has only such competences as we granted to it under the treaties. Very important basic principles of functioning of the European Union resulting directly from the treaties are crucial here. As we know, first, the principle of conferral applies here. It is the most important for the third term I analyze, according to which any competence not conferred on the Union by the treaties belongs to the member state. Second, of course, the principle of subsidiarity, and the third, as we know, the principle of proportionality. The European Union has only the powers that have been granted to it by treaty and cannot be its own power increase, limit, or modify its competencies. Generally, it seems that this is how it should be. The scale of competencies of the European Union are decided only by its member states. A change is possible. A change is the scope of the competencies conferred on the European Union in the treaties may only take place in the ordinary procedure for amending the treaties provided. It is often common assumed that the European Union is a sui generis international organization with some conferred competencies from the member states. The Treaty of Lisbon, of course, explained the final division of the competences between the European Union and Union countries. The competencies are generally divided into three main categories, as we know. The first, exclusive competences. Second, shared competences. Third, supportive competences. It's clear. This is the close and final entire map of the European Union competencies. But how is it in reality? Are they permanent and stable? Today I will say no. Whether criminal law may in the future be the subject of a process of full legal integration between members of the European Union, we will see soon, because it is dependent to which competences in which cases and areas will pass to European Union from member states. Or maybe, there is like this. There is, or will be, a quiet extension of the competence of the European Union in areas that have not been transferred to the European Union by the member states. We will look at the Court of Justice of the European Union as a good example of this process. The starting point here is the process of evolution of the court competences and the process of interference through the sentences of this court in the sovereignty and legal autonomy the member state of the European Union. So let's start at the very beginning and try to little bit sort out a few basic things. It is clear that the Court of Justice of the European Union is the most important body in the structure of the European Union. Therefore, let us consider the scope of competence, which is, in my opinion, is directly defined in a very simple and clear way in the Treaty of European Union, and more specifically in his provision 19. Simple. The Court of Justice of the European Union shall rule in accordance with the treaty setting out the limits of European Union competence in general. These treaties are nothing more than international agreements. Katarina said, pacta sunt servanda, which define this agreement, what the member states have agreed and what commitments they have made in the international organization like European Union is. There are many examples of exceeding the competencies of this court. The case Weiler, Costa Rica, and finally several examples from Poland and Hungary, of course. These cases are the key cases decided by the Court of Justice of the European Union, which concern the fundamental principles of the relationship between national law of the member states and European Union law. They touch on the question of the principles of the primacy of European Union law or national law, the role of national courts, or finally the constitutional limits of European integration and, of course, competencies. All these cases show that the tension between the principles of primacy of Union law and national constitutional principles and the areas of integration and competencies. In each of them, the Court of Justice European Union advocates the primacy, we know about it, of European Union law, but the reaction of national courts indicate difficulties in accepting this principle to the full extent. These issues reflect the challenges of striking a balance between national sovereignty and European integration. In my opinion, for years, it cannot be noted that the Court of Justice of the European Union takes the floor in matters where European Union, in accordance with primary law, does not have competences. That is in case which member states have not agreed to. I repeat, very simple, the European Union and her bodies has only the powers conferred on it by the treaties, principle of conferral. The Court of Justice of the European Union has, in this model presented by me, very complicated competences. I call unfade-moving competences, maybe even aggressive competence. This is very dangerous. Appropriate jurisprudence of national constitutional courts come to the edge where it is indicated that, among other things, Court of Justice of the European Union judgment can be controlled and omitted as a result of this audit. Germany, Denmark, Italy. This brief mention of the position of functioning of the Court of Justice of the European Union highlighted the very important conclusion. The process of assigning competences or the process of very strong extension of competences already granted by European Union member state by the decision-making bodies of the European Union is constantly evolving, and I predict, maybe unfortunately, it will continue to evolve. But, ladies and gentlemen, it is not a new phenomenon. Because I'm talking here about the phenomenon, the spillover effect and competence creep. This is a very visible process. I'm talking about the process of appropriating the attribution of competences by the European Union administration, certain competences that are absolutely assigned to the member state. This is a situation in which the European Union institution, in particular the Court of Justice of the European Union or the European Commission, of course, create through case law or political proposals an extension of the competences of the European Union which belong to the member states. In my opinion, for example, in this spirit of this competence creep, the Court of Justice of the European Union decided without legal grounds to impose fines due to non-performance of the so-called temporary measure, including in relation of my homeland, Poland, for example. The European Commission has started to use common European fund, for example, a tool for financial pressure on countries. This body should not do this, because this body has no legal competence to do so. This is, of course, a topic of another discussion very widely. So, let's back to the criminal law issues. The beginning question has returned. Whether present by me the concept of model of integration will also include the integration of criminal law as a new scope and trends of European Union judicial cooperation in criminal matters? Currently, it is difficult to say, but bearing in mind, firstly, discussion about the European Union model, and in the future, and secondly, the competition creep process presented by me briefly, this cannot be eliminated. I have no doubt that the consent to full European Union interference in the criminal law system is consent to the formation of criminal policy of a given country, member states of European Union. This may be consent to the appointment of joint law enforcement agencies, judges, courts, prosecutors even. Meanwhile, in my opinion, this internal criminal legislation is an important element of the state criminal policy and is an important element of a state of sovereignty. The criminal policy, in overall, in this context is a key term. The key term of a state should always belong to the autonomous competence of a given European Union member state and should never be transferred outside to an international organization, and this type of organization is, of course, the European Union. Why? Because criminal law is directly related to the sovereignty and use of criminal punishment against the citizens of a given country. Our Polish great criminal lawyer, creator of the Criminal Code from 1932, Professor Juliusz Makarewicz, he perfectly described the relationship of criminal law to society in state, for instance. On argued that criminal law is, as it were, a photograph of the political system and social relations prevailing at the moment in a given society. It is simply an exact photographic negative reflecting the social reality of this and not another state. Therefore, criminal policy, as an independent element of the internal functioning of the state, cannot and should be never delegated outside the borders of the state. We don't forget, in general, that the criminal law is an area of public law. This is the essence of the criminal law system. The elemental feature, which also partly results from the aforementioned social contract, belongs to the state authority, is from Latin jus puniendi. Jus puniendi is the exercise of the so-called right to punish an individual as response to the behavior of this individual that is inconsistent with state standards. Therefore, this element in the form of the law of punishment belonging only to the state power makes it dominant towards the individual in given state. So, final remarks. To sum up, I hope that the comprehensive integration of this one of the sensitive areas of the functioning of the law in every country, which is criminal law, will not be fully implemented in the European Union. The European Union has many internal bodies, completely out of universal suffrage, not knowing the specificities of a country, not knowing the social structures of a country, but having a huge impact on the legislation of the member countries concerned. Therefore, there are no, in my opinion, rights to directly interfere in the area of criminal law of a member state. Criminal law is closely linked to the culture, history, and legal traditions of the member state. I'm sure that many countries find it difficult to accept full control of criminal law to the European Union institutions. Another difficulty, I suppose, is that there are many different legal traditions in the European Union, such as continental law, common law, which differ in their approach to criminal proceedings, the definition of crimes, definition of penalties. Additionally, differences in the standards for the protection of citizens' rights in individual countries may constitute an obstacle to full harmonization. Therefore, sometimes this integration of criminal law takes the form, in my opinion, I call the point integration. I also know very well in many examples, for example, the protection of the right of the victim, of the improvement of the child's position in the criminal matters, European arrest warrant. In my opinion, full unification of criminal law at European level is unlikely due to the strong tradition and national sovereignty in this area. But, ladies and gentlemen, it is topic for another discussion, which I encourage. This is also the subject of my article. I hope will soon be published as one of the results of our research group. The title of this article is a European Union Common Minimum Standards for Criminal Proceedings in the Terms of Crime Victims. I cordially invite you to read, of course. Thank you very much.